Ready, start. Facts giving rise to the present proceedings are that the son of appellant numbers 1 and 2 and brother of appellant number 3 was married with the complainant on 14/7/2021. It is the case of the complainant that when the marriage was solemnized, her family had given various gifts to the family of her husband. After marriage, the demand for further gifts was made by the family of the husband from time to time. When the complainant had visited her parental house after the marriage, she had carried with her number of gifts for being given to the family members of her husband. This, however, did not satisfy the appellants, and their demand for further gifts/dowry continued from time to time. It is also the case of the complainant that her husband insisted upon her to engage in unnatural sex, which resulted in causing her mental torture. Ultimately, on 6/2/2022, First Information Report number 20 of 2022 was registered at Bajaj Nagar Police Station, Nagpur under Section 498A, read with Section 34 of the Penal Code. Subsequently, an offence under Sections 377 and 506 of the Penal Code was also added. On completion of further investigation and after recording statements of the complainant and witnesses, the final report came to be filed in the said proceedings. The appellants as well as the complainant's husband filed an application under Section 482 of the Code of Criminal Procedure 1973, praying for quashing of the criminal proceedings filed against them. The High Court, after considering the submissions of parties, found that there was prima facie material on record to proceed with the trial and that the prosecution, as initiated, did not deserve to be stifled. The High Court therefore dismissed the application filed under Section 482 of the Code. Being aggrieved, the accused, except the husband of the complainant, have filed the present proceedings, raising a challenge to the order dated 19/3/2024 passed by the High Court of Judicature at Bombay, Nagpur Bench, Nagpur, in criminal application number 741 of 2022. Mr. Karthik Sukul, learned advocate, along with Mr. Anurag Gharote, learned advocate for the appellants, submitted that on a complete reading of the FIR, it was clear that no offence under sections 498-A, 377 and 506, read with section 34 of the Penal Code, had been made out against the appellants. The ingredients necessary for invoking the said provisions were absent in the FIR, and hence no offence could have been registered against the appellants. The allegations as made were entirely vague in nature, and in the absence of any details whatsoever, it could not be said that even a prima facie case had been made out for proceeding with the trial. Placing reliance on the judgment of this court in Digambar and another versus the state of Maharashtra and another, it was submitted that even if statements made in the FIR were taken at their face value and accepted in their entirety, no prima facie case for proceeding against the accused had been made out.